Your back is crying for help, but who's responsible for the solution? The rise of hybrid working has blurred the lines between office and home, leaving many wondering, should your employer foot the bill for that ergonomic chair? Let's dive into the legal nitty-gritty and uncover your rights, because sitting in discomfort isn't just a pain, it's a productivity killer. Imagine this, your kitchen table has become your desk, the kettle's steam doubles as office ambience, and your trusty dining chair, never designed for 8-hour stints, is now your arch-nemesis. As emails pile up, so does the ache in your lower back. Your manager mentions equipment requests, HR sends a cheerful risk assessment form, and suddenly you're staring at ergonomic chairs priced higher than your university rent. But here's where it gets controversial. Is this your problem to solve, or your employer's? We've all been there, that moment when you realize your body is paying the price for your company's oversight. The answer seems straightforward, but the law is anything but. And this is the part most people miss, it's not about a free chair for everyone, it's about managing risk. What the law really says about your chair. The UK's Health and Safety at Work Act, Management Regulations, and Display Screen Equipment, DSE, regulations are clear. Employers must assess and mitigate risks associated with screen work. This isn't a perk, it's a legal duty. If you're a regular computer user, your employer should conduct a DSE assessment and address any issues, whether that's an adjustable chair, a footrest, or changes to your workflow. No universal right to a chair exists, but there's a clear obligation to reduce foreseeable risks. But here's the twist, the Equality Act steps in if you have a disability, like a long-term back condition. In these cases, employers must make reasonable adjustments, which could include a specialist ergonomic chair. It's not a favor, it's the law, shaped by factors like cost and impact. Real-life stories and the gray area of home working. Take Sam, a hybrid project manager in Manchester. After months of battling a stubborn chair, a DSE assessment flagged posture issues. The solution? A mid-range ergonomic chair, a monitor riser and a footrest, not a luxury, but a fix backed by evidence. The stats are eye-opening. The Health and Safety Executive reports hundreds of thousands of work-related musculoskeletal disorders annually, costing millions in lost productivity. It's not just about chairs, it's about long hours, poor setups, and small compromises that add up. Remote or hybrid, the rules don't change. Employers must manage risks, whether through equipment, task adjustments, or training. Buying a chair on your own and expecting reimbursement. Rarely a winning strategy. If a risk assessment recommends equipment, the employer is on the hook, that's the law's backbone. How to ask and actually get help. Start smart, request a DSE assessment in writing. Keep a symptom log and suggest tiered options, good, better, best, with prices and links. Include medical notes if applicable, and mention access to work for disability-related support. Frame it as a risk reduction measure, not just a comfort request. Pro tip: attach a photo of your current setup and highlight productivity impacts. Employers respond to evidence, not ultimatums. Common pitfalls. Avoid demanding top-tier models without justification, buying first and asking later, or ignoring quick fixes like screen height adjustments. Position it as a shared solution, not a demand. As one employment lawyer puts it, you're proposing a reasonable control for a foreseeable risk, exactly what the law expects. When the answer is still no. What if your request hits a wall? Budget freezes or rigid policies can stall progress. Here's where persistence pays off. Put the risk assessment outcome in writing, ask for alternative control measures, and escalate if needed. For long-term conditions, invoke the Equality Act and request an occupational health review. If all else fails, ACAS offers guidance on next steps. Quiet persistence beats righteous fury every time. Key takeaways. Employers must manage DSE risks for all regular computer users, even at home. Know your rights, not just myths. The Equality Act can mandate specialist equipment as a reasonable adjustment. No isn't always the final answer. Evidence-led requests with tiered options get approved faster. Practical steps you can take today. FAQ. Question: do employers have to buy ergonomic chairs for everyone? A. Not automatically. They must address risks identified in a DSE assessment, which could mean chairs, footrests, or workflow changes. Question: does this apply to home workers? A. Yes. DSE duties extend to home setups, with employers providing equipment, guidance, or task adjustments. Question: can I get reimbursed for a chair I already bought? A. Unless pre-approved, reimbursement isn't guaranteed. Frame it as a goodwill request and focus on future purchases through proper channels. Question: what if I have a long-term back condition? A. The Equality Act may require reasonable adjustments, including specialist chairs. Access to work can help fund equipment, a clinician's note, and occupational health referral speed up the process. Question: are there tax implications if my employer buys the chair? A. If the chair is primarily for work, it's typically not taxable. Self-purchases are rarely tax-deductible. Always check HMRC's latest guidance. Now, the controversial question: should employers proactively provide ergonomic equipment, or is it the employee's responsibility to flag issues? Share your thoughts in the comments, let's spark a discussion.